We are on record for preliminary hearing today. We've made some time for Mr. McFarland to talk with his client before we get started, and now we are ready to go. I have the names of our participants, please.
Lee Jameson Heiss, lawyer, guardian ad litem.
Ms. Thomas, counsel for the department. Ms. Trout.
Hannah Trout with the department.
Michael McFarland representing Father Charles Sherwood. Charles, please introduce yourself to the court.
Charles Sherwood.
Thank you.
Okay, who's coming in from the BLU B135BL device? If you could give us your name, please.
Jalen LeBaron.
Okay, thank you. All right, so I'm going to go through just a few things with your client, Mr. McFarland, but if you'd like to let us know what direction you're headed this morning, I think that would be good.
My client is in jail, lodged on the allegations of child assault. That's the allegations, the principal allegations of the petition. We will then be asking the court to accepting no contest plea. He has received the petition. He's read the petition. He does not need it read. He does not have any Native American heritage. I am informed that mother does. Eastern Band of Native American Cherokee, and inquiries have already been sent out.
Yeah, there is some mention of a divorce case that may concern the minor children. Were you able to talk to him about whether or not there's any other cases that concern the children named in this petition?
I did not hear.
All right. All right, Deputy Ames, would you please swear in Mr. Charles Sherwood? Okay, good morning, Mr. Sherwood. Can you hear me okay?
Yes.
Good. All right, were you able to hear everything that Mr. McFarland offered on your behalf?
Yes.
Do you agree with all of the things that he talked with us about?
Yes, I do.
All right, very good. I see that there is, it looks like 2 separate divorce cases about the children through Jackson County. Are those the only other cases that concern the children that you're aware of?
Yes.
All right, very good. Well, I'm sure your attorney has talked with you about this as well, but I just want to remind you that you do have the right to a trial on the allegations in the petition. And that trial may be before a referee, unless a demand for jury or judge is filed. Right now, we don't have a referee, so it will be scheduled in front of the bench if you decide you want to do that. But as I understand it, you'd like to enter a no contest plea. And I'll go over what it means to waive those rights with you in a few minutes, assuming that the rest of the attorneys agree that that no contest plea is in the best interest of the children. I just want to also remind you that you have the right to an attorney, which is why Mr. McFarland is here. If you choose to retain your own private counsel, that person would need to reach out to Mr. McFarland and get all the case information from him. And then, of course, file a substitution letting us know that you've replaced him. But Mr. McFarland will be here regardless, so that you have an attorney for this hearing as well as all hearings moving forward. Do you understand that?
I do.
All right. So part of what I have to decide today is whether or not to authorize the petition. And whether or not where the children are currently staying is the safest and least restrictive environment that they're in. Mr. McFarland has covered a lot of the other things that I would have already asked you. But do you have any other questions this morning before we go any further?
I do not at this time.
All right. Let's go to our attorneys. Your position on the no contest plea, Ms. Thomas.
Your Honor, I believe that is appropriate at this time.
Ms. Heiss.
Yes, I think it's appropriate and it'll allow the family to get into services sooner towards a resolution.
Well, all right. Well, at this time, Mr. Sherwood, then I'm going to go over your trial rights with you. A no contest plea essentially means that I will be looking at the petition. The department may put on some testimony to verify that, but basically what it means is that you won't have to speak to the allegations in the petition, but I would assume that they're true. For purposes of deciding whether or not to take jurisdiction in this case. You've already told us we don't need to read you those allegations, but I just wanted to let you know for purposes of the no contest plea that essentially I'm just accepting those as true. Do you understand that?
I do.
Okay. If you're giving up your right to trial, we're giving up your right to trial if you enter a no contest plea, you're giving up your right to a trial by judge or by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath at trial. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I've just indicated to you if you enter your no contest plea today?
I do.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regards to the plea itself, a plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Mr. Sherwood?
I do.
Do you have any questions about any of the information I've given you so far?
Not at this time.
Are you currently under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing right now?
No.
All right. Is anyone making you enter a no contest plea?
No.
Has anyone threatened you in order to get you to enter a no contest plea?
No.
Has anyone promised you anything in order to get you to enter a no contest plea?
No.
In your opinion, is your decision to enter a no contest plea one you've made of your own free will?
It is.
Thank you. All right. Ms. Thomas, we'll go to you now for purposes of the factual basis of the plea, please.
Thank you,
sorry?
Judge.
I'm sorry. Sorry.
That's okay, Mr. Sherwood. Ms. Thomas is going to provide the factual basis of the plea now. Thank you.
Thank you, Judge. If Ms. Trout can be sworn in, please.
Ms. Trout, come on up to our
Thank you.
witness stand.
Ms. Trout, can you I am so sorry. Dogs are barking. I'm going to close my door.
Maybe they didn't get breakfast.
Some say dogs, some say children.
Yeah, they like to be security for the front window, so it's really fun. Ms. Trout, can you please, for the record, explain how you are familiar with this matter?
I received, excuse me. I received this case last Monday. I was the on-call worker, and then the following morning, I was the assigned investigator for the case.
And you are the one who drafted this petition, correct?
Correct.
And as it relates to the allegations that you put in the petition, how did you gather that information?
I spoke to the child, the father, both of the mothers in the case, and law enforcement in the hospital.
Okay. And were you able to personally observe the child?
Yes.
Okay. And based on your conversations and observations, what do you believe that there is a substantial risk of harm to the children if Mr. Sherwood were to be in the home today?
Due to his past history with child abuse, with other children, and then this current investigation, there are concerns of repeating issues. And if he returns to the home, there are younger children that would not be able to defend themselves.
And the allegations in the petition include that there was a physical altercation, I believe, between Mr. Sherwood and the oldest child that's in the home at this time. Is that correct?
Correct.
And did the child sustain any injuries?
He did.
And what were those injuries?
He had multiple bruises and scratches on him, just like superficial abrasions. He also had a sprained shoulder.
And based on your conversations with the children or with the family, are there concerns about appropriate parenting for the children?
Yes.
And the oldest child, his mother, was she able to obtain a custody order to take that child?
Yes, so she filed their custody through Jackson County, but I believe they have court on the 10th for that.
Okay. Is that youth currently safety planned with the mother at this time?
He is safety planned with the mother, but he has been staying at his grandfather's just by choice.
Okay. Is there any concern about that on your end?
No,
Okay. And the other children, they remain with the non-respondent mother in the familial home, is that correct?
correct.
Okay. And do you believe that that arrangement or those arrangements are the least restrictive to ensure the children's safety?
I do.
Okay. Were there reasonable efforts to prevent this petition from being filed?
Due to this petition being a mandatory petition, I did not offer any services currently, but during past investigations, there were services offered, and he participated in services through probation when the 4th degree child abuse charge came up.
That was in 2018?
That sounds correct, yes.
If, and let's just, for argument's sake, if there are no bond conditions or no conditions related to the criminal case preventing communication or parenting time with his children, what is the department's recommendation regarding parenting time, if there is one?
We would recommend just the standard parenting time. Usually it's a couple hours a week supervised, or a couple days a week supervised.
Okay. Do you have any updates on the pending criminal matter?
I do not have any updates right now.
And then this is not for the factual basis, but for ICWA documentation, you were able to provide the certified mail receipt indicating that something was mailed to the Eastern Band of Cherokee Indians. What documents were sent there?
It was the DHS 5598.
Okay. And that was done on 5/21. So there's no green receipt yet, correct?
Correct.
Okay. Thank you. Okay. With that, Judge, I have no further questions for Ms. Trout for a factual basis.
Mr. McFarland?
You will not be the ongoing worker, correct?
Correct.
Anticipate my client will make bond today or tomorrow. Who will he be meeting with to set up a case service plan?
The worker will be Chris Farian.
Thank you. Nothing further.
Mr. Faring is logged in. He doesn't have his video on, but he is logged in.
Oh, thank you, Your Honor.
All right. Would you be able to get us a copy of the custody orders establishing custody and the most recent order that informs on custody and parenting time arrangements, please?
Jackson County wouldn't give me everything. They only gave me very little of each file, but they provide what they were going to give to me.
Thank you. Because I would like verification of the legal parentage for Mr. Sherwood as it relates to all 3 children and the custody arrangements. I know you said there's a court date coming up on the 10th.
Yes.
So any order that comes out of that hearing. All right. Could you tell me do you know what the visitation and custody arrangement was for the children and the parents?
So in regards to the oldest child, he stayed primarily with his dad, but he went over to visit mom just randomly whenever he wanted to. The other children, even though there was the custody set up through the divorce, they all lived in the same home. So there was they never followed any order.
You say they lived all in the same home. Who were you referring to?
Sorry, the 2 younger children, Brittany and Charles, lived in the same home.
Is that still the case?
Now that Charles is incarcerated, it's not.
If he's released, will that be the case?
From my conversation with mom this morning, that is not going to be the case.
Are you confident in that arrangement? Where is he going to stay if he's not going home?
So when I talked to him over Zoom a few days ago, he said he has a couple friends that he could stay with. Or if it comes down to it, he said he could sleep in his car. But one of his bond conditions was going to be no contact with children under 18. And Brittany said that she will she's confident she will follow that.
Have you talked with her about what she intends to do moving forward to keep the children safe from further incidents?
She does not plan on getting back with Charles to ensure the safety of the other kids.
All right, sir, we'd be happy to try to grab you some water. I think there's a fountain in the hallway. Okay. Sorry. Ms. Heiss, did you have questions?
Just briefly, do you have a police report at this point?
I'm not sure. I would have to double check. I don't believe so because the investigation is still ongoing.
Dad has been charged?
Through the prosecutor submitted charges, yes.
Okay, and then you said in your testimony that you had talked to Dad. I didn't see that in the petition. Did he admit the charges?
He admitted to smacking, but he denied everything else.
Okay, and then will you be willing off the record to give me the address, contact information for where I can find the child whose initial is K with his grandparents?
Yes.
And then, so Charles was divorced from Kay's mom.
Yes.
Prior, and he was also divorced from the younger two children's mom, correct?
Yes.
And those are both Jackson cases?
Yes.
Okay, thank you. I have nothing further.
Any redirect, Ms. Thomas?
No, Judge, thank you.
Mr. McFarland?
No, thank you.
Okay, thank you for your testimony. You may return to your seat. Thank you. Anything else for purposes of the factual basis of the plea, Ms. Thomas?
No, Your Honor.
All right, are you also satisfied with the advice of rights?
I am.
Mr. McFarland, are you satisfied with the advice of rights and the factual basis of the plea?
Yes, Your Honor.
Ms. Heiss?
I am, thank you.
Ms. Heiss, do you find it to be in the interest of the children, the best interest of the children, for me to accept the no contest plea?
Yes.
All right, I would agree. I think that based on the allegations of criminality, the court is appropriately accepting the no contest plea. Clearly, Mr. Sherwood has current criminal charges that arise out of the same facts and circumstances, and those are the same charges that unfortunately find him appearing to us from the Lenawee County Jail this morning. So a no contest plea is appropriate for those reasons. I do find further that the plea itself was knowingly, understandably, and voluntarily made with a full understanding of the consequences, and that through confirmation of the allegations in the petition, as well as the testimony of Ms. Trout this morning, that there has been a violation of the statute, namely that the parents, the home or environment of the children as a result of Mr. Sherwood's actions is unfortunately holds a substantial risk of harm as a result of the physical abuse of the children. There are also further indications that this is a long-standing pattern, unfortunately, that Mr. Sherwood really needs to be offered services for if it's going to change. And also that this particular parent has, by also taking those actions or inactions to prevent the physical abuse of the children, subjected them to substantial risk of harm to their mental well-being and physical well-being. So for those reasons, the court is taking jurisdiction, has jurisdiction over the children, as well as Mr. Charles Sherwood moving forward. Ms. Brittany Sherwood will have the placement of the children. Ms. Thomas, what is your position as it relates to the arrangements with Mr. Sherwood? Understanding that there may be bond conditions, but is the department asking for an order removing him out of the home as well, or are you satisfied with the safety plan?
Judge, at this time, we are asking, as it relates to the two younger children, that he be ordered out of that family home, as that was the family unit before the petition. And then as it relates to the older child, we are just asking that he be released to his non-respondent mother.
Mr. McFarland?
Well, I understand my client's going to have no contact with minor children. So I think that speaks for itself.
Ms. Heiss?
Your Honor, even a no contact in this case would protect the children or removal. I'm looking here for whether removing, the prayer request was removing the children from the respondent father's care or the respondent father out of the family home. Yes, I think that's appropriate. Thank you.
Thank you. I would agree. We don't have bond conditions currently in place. I would certainly hope that our criminal courts would take that into consideration, but in the event that they don't, I think that it's necessary to safeguard the environment of the children and to be very clear with Mr. Sherwood, as well as Ms. Brittany Sherwood, that there will be no, there should not be any occasion for Mr. Sherwood to be in contact with any of the children or to be at the home. And so that order will be in place preventing Mr. Sherwood from returning to the home. There will also be a component of the order that indicates that Brittany Sherwood is not to allow him to return to the home. So I don't think she's here with us. Oh, she is here. Good. I'm glad you're here this morning to hear this, because the order will also apply to you. So please be aware that if you allow him to come back to the home, you will have to also explain it to me. Any questions about that? She says no. Very good. So that will be in place as part of things moving forward. Mr. Sherwood, between now and when we come back for your initial disposition, Mr. Farian likely will be the one that reaches out to you to look at a case services plan. I see from the petition that you may have seen something like this before, but Mr. Farian will be working with you to identify services targeted to alleviate the risk of harm to the children, the physical abuse patterns, or abuse patterns in the home, and hopefully you'll be able to tackle those as part of some programming moving forward that may help you with this case as well as potentially in your criminal matter. So we'll come back in the next month or so for the initial disposition. I will give you a date for that now. Looks like I have some time. Well, I have Monday, June 17th at 3 o'clock, if that works.
Yes.
That's fine.
Yes, Judge.
Very good. So that will be the date and time for your initial disposition, Mr. Sherwood. If you're still at the Lenawee County Jail, we will surely make arrangements for you to talk with Mr. McFarland ahead of time. And Mr. Farian will be tasked with navigating that in order to make sure that he touches base with you as you put together that case services plan for purposes of the hearing on Monday, June 17th. Do you have any other questions today?
No, not this time.
Garner, when we're off the record, could we get some contact information for the court?
We're coming together today for the disposition in this case. May I have the names of our attorneys and participants, please?
Lee Heiss, lawyer, guardian ad litem.
Nastasia Thomas, counsel for the department. Mr. Farian.
Christopher Farian for the department.
Michael McFarland, representing father. Please introduce yourself, sir. Mr. Sherwood. You're muted, sir. You have to unmute.
Charles Sherwood, father of the children.
Thank you. All right, Mr. McFarland requested a few minutes.
Yes, Your Honor, my client has been in communications with me, and we spoke again today. Part of his concern is he has a future criminal case that's proceeding, and asked for an adjournment. And we had discussed this was just entry into the case service plan today. Part of the problem, though, with that, if there's a psychological evaluation, if there's counseling or anything, if they wish for him to describe or perhaps make admissions to anything that goes on, he would have to take the fifth on that, since we've entered a no contest plea here. So I don't want to do anything that might jeopardize his criminal case. He had asked for an adjournment, realizing that he to start his services, he can voluntarily start services right now, but that's a concern that I have, and I'd like to at least put him on the record as to what he wants to do, just to give the court a heads up. But I think maybe an adjournment might be appropriate because of that point of order.
Ms. Thomas, your position?
Your Honor, I understand it. And I don't know that we necessarily need an adjournment. I think we could maybe find a resolution short of adjourning the initial disposition, so Dad could at least start in some service. We could add language that these things are to take place at the resolution of the criminal case. I'm not opposed to that, but right now I don't know that we necessarily need an adjournment.
Ms. Heiss?
I'm checking on the court dates for Dad's hearing. I would also like to progress with the disposition because, one of the things the kids are asking for is generally to progress towards supervised visits. And I'd like to get into a position where if the criminal court allows contact, that Dad and children are prepared for that.
We have no objection with that, Your Honor. The only thing is we don't want it to be taken as as refusal to participate, just that he really can't answer any questions regarding the factual basis of this. Other than that, he's fine by that. Just wanted to confirmation.
Well, I can appreciate his concerns, but the case is centered obviously around the children. And we have 3 children in this case who need their parent to be available to them, regardless of what's happening on the criminal side of things. And I can't, in good conscience, ask them to wait until the resolution of the criminal case in order to do that. So I will, I can tell you this, I'll take clearly into consideration that there may be pieces and parts of his case services plan that he may not be able to fully engage with, given that concern. And I would not expect him to compromise his right as far as his right not to self-incriminate.
I'm satisfied with that, Your Honor.
That being said, let's go ahead with the disposition. Your comments, Ms. Heiss?
Your Honor, I have visited with all the children face to face, and as the report indicates, the little guys are interested in visiting with dad eventually, so that there's a process that happens to make that happen. I even think the older child needs to be prepared for the time when the criminal case is resolved. It seems to be a very close family. This young man, that it was the victim of the assault, you know, he's ready, whether the case, whatever state the case is in, he's ready to start working on. So what do we do going forward? He lived with his dad and had a whole life that's been disrupted. And yes, his grandfather is meeting all of his needs. Technically, he's placed with his mother, but his grandfather is meeting all of his needs. They're on my way home every day, so I double check to make sure he's doing some chores. And his grandpa had a motorcycle accident, so I especially thought that he should be doing some chores. But he's very respected in the home. He respects his grandfather. Mother is there very often. The 2 littles have a younger sibling in the home, and they all are missing father as normal, a missing father. And I don't want to encourage cheating, meaning dad visiting the 2 littles when he's not supposed to. So I think that it's fair to prepare everybody for the day when this family will reconnect and move forward. And the case service plan is aimed at what we need to get this family recovered. I do see the problem with the psychological evaluation, but I think we can assume some of the issues in play and start addressing those before, even without that. So a lot of strengths in this family. And I know that this situation happened with dad, and I don't know, I think they're nice people, and I think that eventually in the family case, we're talking about some forgiveness, and we're talking about rebuilding some family connections with some boundaries in place. Thank you.
Nice. I'm sorry, Ms. Thomas.
Oh, that's okay. If Mr. Farian can be sworn in, please. Mr. Farian, you've prepared a court report for today's hearing, and you've also included some attachments. Can you review what those attachments are, please?
Yes. So, first of all, I had the court report. I had the case service plan that Mr. Sherwood and I had completed together. Most of any services were requested by him. I'd like that to be known. He was very proactive. I also had the 2 friend of the court for the children, one being for his children. And then thirdly, there was a copy of the police report.
Thank you. And currently, Mr. Sherwood is ordered out of the home. Is that correct?
That is correct.
And what is the permanency goal for the children?
I'm sorry.
Hang on. Now, well, we've got the interruption
Okay.
already. So what's happening over here is Mr. Sherwood, we appreciate your fashionable choice, but for court hearings, we would ask you to take your hat off, please. Thank you. If you could repeat your question, Ms. Thomas.
What is the current permanency goal for the children?
Reunification.
Okay. And just briefly, can you remind us of the barriers to reunification?
Yeah, currently there is a court order that he's not to have any contact with, I believe, children under the age of 18. That includes his own children.
Okay. And are there other concerns, parenting, anger management, any of those things?
Not to my knowledge, other than obviously the situation that brought us here today. And there is some historical incidents of abuse in the past as well.
Okay. And are there any services that Mr. Sherwood has voluntarily started to participate in to reduce the barriers to reunification?
I do not know that he started. I have not met with him this month yet. I know that when we met at the end of last month, he had asked for some places that he could do some counseling. He was given us several names for that. He was also provided with MSU extension for some parenting classes and things of that nature. And then the psychological has not been provided yet, so that would be the only other thing, and he had requested that as well.
Okay. And are there any services in place for the children?
Not at this time. I will be honest with you. I got this case late last night. I've been trying to get a hold of the victim's family multiple times. At this point, I believe I'm going to just have to start knocking on doors. I have not gotten a response. So I do not know what his needs are at this time. As for the two younger children, no, the only thing was mom had indicated that, possibly some counseling for them, but they just definitely, as Ms. Heiss indicated, wanted to see their father. So.
Okay. I'm sorry. Can you just clarify? You said you got the case late last night, but
No, late last month. I'm sorry.
oh, okay.
Did I say last night? I apologize. Last month here. Last month.
Okay. All right. And is there anything else you want to provide to the court today?
No, I'm good. Thank you.
Thank you. I have no further questions, Your Honor. I'm going to move to admit the court report with the attachments.
No objections.
No objection.
Okay. Those are received. Questions, Mr. McCraw?
No.
Ms. Heiss?
Just briefly, do you have the bond conditions for Mr. Sherwood?
I do not have them currently with me.
But you have looked at them and reviewed them?
It's been since the beginning of the case, yes, but so I haven't done anything currently. And to my knowledge, in talking to Mr. Sherwood on the phone, he has indicated that they're still the same.
So still the same. It looks to me from the computer that there's no contact with the victim. Is that what your paperwork says?
I would have to go back and review it. It's my understanding that it's been with all of the children.
And then he's bound over from district court to circuit court, so there may be a change in bond conditions. Have you checked those felony bond conditions?
I have not.
Okay, because this is why I wonder, our last order says that any visits with the father would be harmful. And so in the event that that's the only thing preventing him from seeing the younger children, we would know that, as opposed to whether his bond condition also requires him not to see the younger children. And then August 7th is his next hearing in circuit court for his child abuse case. Does that sound right?
I thought he indicated there was one this week, but yes, I was aware of the August 7th date as well.
And he's being charged with this child abuse second degree and assault with GBH?
Yes.
Yes, okay. Thank you. I have nothing further.
Mr. Perry, do you know, are there any updates past the June 10th date of hearing? It looks like the referee in Jackson County held a hearing regarding Jalen LeBaron and her child. Do we know what happened at hearing?
I do not, Your Honor. I can look into that further.
Actually, all right, any questions based on my questions or redirect?
No,
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 Any other testimony?
no, Your Honor.
Ms. Or Mr. McFarland, any testimony today?
I'd like to have Mr. Sherwood sworn in, please. Mr. Sherwood, I saw you nodding your head in the negative regarding your bond conditions. Can you tell us what are your bond conditions?
My bond conditions are no contact with my children. The under 18 was dropped.
Thank you. Okay. You heard the judge indicate today that if you enter into the case service plan, she'll take into account some things, as I had mentioned, as though you won't be incriminating yourself. And, like when you meet with a psychologist. Do you understand that?
Yes,
And today, based upon our discussion, you would like the court to then enter you into this case service plan. Is that correct?
yes.
Do you have any questions about the case service plan?
Not really at this time.
Okay. I have no further questions then. We'll see if other attorneys have questions for you.
Ms. Thomas?
I have no questions. Thank you, Your Honor.
Ms. Hess?
yes, sir, did you go to a court hearing regarding and his mother on June 10th in Jackson?
Yes. The mother
Okay, do
did
you
not
know-
show up.
Say that again?
The mother had not shown up. That is not the
Okay.
first time she missed a court date. And the last time we were in front of the judge with our court, she told the judge she didn't care what kind of custody I had. She just wanted to be able to see him.
Yeah, all right, so, your last custody order then in place,
Is my custody. This is where they gave me custody of.
okay, and then, nothing happened then to change things in June?
No, there's another court date scheduled. I'm not sure on the date. With working and everything, I haven't had a chance to get up to the post office to get the first class mail that was sent.
Okay, did you receive the order after last time we were here?
For the Jackson FOC,
No, this is regarding the Lenawee CPS case.
I don't think I have.
All right, so you'll want to stay on that and watch for an order after today too, right?
Okay,
The last order says that you're not to visit the kids, and you know that, but it also says, you're not allowed in the family home.
correct.
Okay,
Doesn't live there.
say that again?
And does not live at my house anymore. That's what.
Right, but are you in the home of the other two children?
No, I am on a tether, which prohibits me from going to that address.
Okay. And you're not having visits at this time with any of the three kids?
No, I'm not.
All right, and then you're willing to participate in what you can do to be ready to have that relationship again?
Yes.
Very good. Do you think any of the three kids have any needs that aren't being met?
I'm concerned then, yes.
All right, do you know that I'm accessible to you and you can contact me so I can investigate what your concerns are, okay?
I have no idea. I didn't even know you were part of the case.
All right, that's all, Your Honor, thank you.
You redirect?
Now, I don't want to use children's names, but in the child you just mentioned, what are your concerns?
On how he's being taken care of. I heard that she said that she stops by there and says that he does chores and stuff, and that his mother's there all the time, which I do not. I don't believe that part. And I'm concerned with. I mean, I'm sure he's getting his food and clothing and stuff, but I'm concerned of the supervision that he's getting while he's in their care.
What's your concern about the supervision?
Because they don't watch him. They let him go do whatever he wants, where he wants, when he wants. They don't ask questions. There's been multiple times now that him and his friends have been prank calling me. And just as of last night, he tried to make a $50 purchase on PlayStation with my credit card.
Thank you for bringing that to our attention and to the workers' attention and the guardian ad litem so that can be investigated. Thank you. Nothing further, Your Honor.
Any other questions for Mr. Sherwin?
No.
No, Your Honor.
Thank you. Anyone else would like us to hear from Mr.
One question for Mr. Ferry on your own.
Go ahead.
What should the priority be of my client as far as going through the case service plan?
Well, I think that he's indicated that he wanted to do some parenting classes, and he and I will probably meet this week or the beginning of next week. So if he needs some further help in identifying which ones would be the most beneficial, we can start there. I do know that he, again, and I haven't spoken to him since we had this conversation, but wanted personal counseling for himself in terms of therapeutic, I might have even been domestic violence type counseling. So where he is on that process as well. I think those two things would be the most beneficial to start.
Do you think John Bailey might be a good place for that type of counseling for him?
I believe I did give him John Bailey's number, as a matter of fact, and I also gave him Miss Brene Moore, who will also do some domestic violence counseling.
Lastly, you heard his concerns about the son, C, the first letter. It's K. K. Presuming he'll now explore some of his concerns.
Absolutely. I know that he's voiced some other concerns for me at one point. I did look into those. It was a temporary issue when the grandfather was involved in that motorcycle accident, and he had to be with his mother, and then he was with the other grandparents that there were concerns about. So that has been resolved to my knowledge.
But the new concerns, you'll.
Yes, I absolutely will. Absolutely will.
Nothing further, Your Honor.
Any other questions for Mr. Farian?
No, Your Honor.
Just briefly, why don't we just place with the grandfather?
I have no objections to that, other than the fact that I have not been able to go to that home personally. I've been trying to get in touch with the grandfather and the mother. Now, mind you, again, as I stated, I will be going out and making fun announcements this week if they don't return my phone calls.
So are either father or mother paying child support for the oldest child?
Not to my knowledge.
So this is an unfunded placement. Grandpa's doing the work and he has no financial support.
Right, and it's been indicated by the previous worker, the investigator, who I've had extensive conversations about, specifically about that placement, and 100% agrees that it's a good place for him at this time.
Yeah, so if we can get funding to support it, maybe some of Dad's concerns would be allayed. Okay, no, nothing further, Your Honor.
Okay, thank you for tracking down the custody orders.
Yes.
All right. Anything else for today then before we close?
Not here, Your Honor.
Nothing further.
Any
No, Your Honor.
comments?
No, Your Honor.
Nothing further.
Very good. The court finds all interested parties were given notice for purposes of today's initial disposition as it relates to Mr. Sherwood. The case services plan is targeted to assist him in educating himself and working on behavior changes that would provide safety in the home for his children and of course during visits as well. This court cannot supersede the criminal case for purposes of bond conditions. We could put Mr. Farian on to asking whatever counselor gets involved for a recommendation on parenting time so that when the criminal case bond conditions are resolved, we will know how to approach that moving forward. So I'll ask him to look at that for parenting time recommendation so that if and when the criminal case releases their parenting time suspension, we'll know whether or not it's safe or how to make sure that parenting time is safe and productive for Mr. Sherwood and his children. In the meantime, I will ask him to get started on as much of his case services plan as he can in order to make sure that we are making headway so that his time with his children is effective, safe, and creates a healthy bond between him and his children who obviously need him. He has had his concerns heard today as well, and I appreciate him sharing those for Ms. Heiss and Mr. Farian to look at pending our next review hearing. But the case services plan will become part of today's court order. The children are in the safest and least restricted placements with their mothers, although I will trust the department to continue to look at that issue that was raised by Ms. Heiss as well, related to the grandfather's very large role in the life of his grandson at this time. We'll set a review date. Our initial first review of Mr. Sherwood's progress will be conducted at 10 o'clock on October 7th. Assuming everyone will be able to join us at 10 a.m. on October 7th. Sure.
I'm available. Honor.
I'm
I'm sure I am as well then.
Okay, very good. That'll be our first regular review. Unless there's any questions, that's all for today.
Versus Charles Thomas Sherwood. We are here today for a pretrial hearing. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record?
Phoebe McClure, on behalf of the people.
Elias Muad appearing on behalf of Mr. Sherwood.
All right, and Mr. Sherwood is here in the courtroom in person. So Mr. Muad, where do we stand with Mr. Sherwood's case today?
Judge, Ms. McClure and I talked yesterday about seeing if there were medical records pertaining to the victim's injuries. I would ask, and because if there are, it's going to take a little time. Would the court give us a late September date to see if it exists? And then I think my client, Mr. Sherwood, and I are going to have to talk about the next step, and hopefully we'll have a decision made by the end of September, Judge.
Ms. McClure, anything you need to address from the people's side today?
No, and I wouldn't even object to going into the first part of October, just because then I'll be in a pretty lengthy trial and I might not have a chance to talk to Muad at the end of September. And I think we're both on the same page. If we don't get it resolved, we'll be ready to set it for trial then.
All right, how about October 9th at 8:15?
Okay. I will prepare the order. Ms. McClure, can I sign your name to it?
You can.
Okay, great. And I'll just send you a quick email reminder what we're doing. And I've got the other case I got to do some stuff on too.
Yep, and I did a further investigation request for those medical records, so hopefully they get those to me.
Okay, it does look like we need prints in this case, so I'm going to do an order for fingerprints.
Judge, on October 9th, I have in the book arraignments only, no criminal docket.
Okay, can we do October 16th instead of October 9th?
Fine with me, Judge.
Yes.
Okay, so October 16th. And again, I'm going to do an order for fingerprints. So Mr. Sherwood, you'll need to go back to, looks like Rollin Township who was the arresting agency in this, and arrange to have your fingerprints taken for this file.
the state police request to.
Okay, you'll need to contact them. Okay, anything else we need to address in this case today?
Oh, thank you, Judge. Thank you very much.
Okay.
Mr. Sherwood, I will give you a call. Thank you, Phoebe. Appreciate it.
Yep.
In this manner, may I have the names of our participants, please?
Lee Heiss, lawyer guardian ad litem.
Ms. Tasha Thomas, counsel for the department.
Christopher Farian for the department.
Give me a court convening. I'm Mike McFarland, representing father. Please introduce yourself, sir. Charles Sherwood, father.
Thank you, I appreciate that. I think we also have Ms. Jalen LeBaron and Brittany Sherwood available online.
Yes.
I'm not online.
Oh, that's right, you're here. Okay, all right, thank you, welcome, ladies. All right, I look forward to your update, Ms. Heiss.
Thank you, Your Honor. I did visit with the children, the younger ones in person. So there's a pending criminal case in this matter that is in felony court, and there is a pretrial in the next week or two. The attorney on that case is Mr. Muad, and when I visited the children, I do believe that the amount of time that has lapsed is with the father out of the house is causing some stress on the family. That so the progress that's been made to date, even though the criminal case called out and we don't have someone on probation, I think that we need to start contact. I think for the children, they want contact with their father. So I think that the agency can help me work on whether that's therapeutic. The oldest child has a therapist that he attends or has in the past that we could reconnect with and reintroduce dad and the child in a therapist and move to supervised. The households are stressed, and of course we don't want to put someone who's not in their best interest back into their lives, but I do think dad has done some work, and that this family, these children do need that contact. The stress that I see is, households where one mom is holding down the fort with 3 kids who, and all their needs are met for sure, but the children really have a strong desire to see their dad. And I don't think that's contrary to their best interest. So that concludes my report. Thank you.
All right, Ms. Heiss, it would appear to be a conflict with the bond conditions that have been in place through the County of Jackson for the court to authorize parenting time or contact between the children and their father. Are you familiar with that barrier?
I am, and that's why I've contacted Mr. Muad regarding that, so that we could, if we get your approval, that it would benefit the children. If that can be coordinated, I would like to be part of helping that case. I thought it was a Lenawee case, but maybe it's a Jackson case. Anyway, there's also custody cases on this. These children lived with dad full time. This incident happened, and this dad is able to show me some benefit that he's had from services, and I just think it's time for contact to start in their best interest, and I'm willing to track those other cases.
Thank you. Ms. Thomas.
I don't know, call Mr. Farian.
All right, Mr. Perry, come on forward. All right, Ms. Thomas.
Thank you. Mr. Farian, you provided us with a court report today, and it includes the case service plan for Mr. Sherwood and 2 certificates indicating completion of some parenting time classes. Is that correct?
That is correct.
Has there been any other documentation that's been circulated since you filed this?
Mr. Sherwood did provide me with another completed form in terms of another online class that he completed through U Extension. I believe I encouraged him to bring it to court and that everybody could see it.
Thank you. And is that the 1.5 hour parenting education for a program called Relax, an alternative to anger for parents and caregivers?
Yes.
Okay. Generally speaking, I know that as Ms. Heiss indicated, and I think we're all familiar, there is this pending criminal matter, but otherwise, has Mr. Sherwood been compliant with the elements of his case service plan that he can be?
He has. We do have a psychological that he requested in the beginning that is scheduled for, I believe, November 4th at 12:30 p.m. And that's through Battle Creek and Associates out of Hills. It'll be conducted in the Hillsdale office.
Have you had to do any random drug screens this review period?
I have not. I've never thought that substance abuse was a part of this case.
And currently, is his housing appropriate? Best of your knowledge?
Yes, so he's temporarily living at his parents' former home. They actually moved across the street from him. So, but it's a nice house. I mean, all the working utilities and everything. I believe that if things were to resolve themselves within the criminal in this court, he would return to the home with Thomas, his younger children, and Brittany Sherwood.
Are there any concerns about financial stability, like through employment or anything like that?
No, he's been employed this whole time.
And has he maintained good communication with you?
Absolutely.
If the bond conditions were modified to allow contact with his children, would you be in agreement with that recommendation?
So, yes, specifically the two younger children, I think it would be beneficial for them. As for his older son that was the victim on this case, I think that there needs to be some sort of, I'm concerned with some of the things that this young man voiced to me in terms of trying to take ownership for everything that happened in a way that it's all my fault. I think that somewhere that needs to be processed a little better. He does have a counselor. This young man does have a counselor through, may I look at my notes? I can't remember the name of it. Thank you. There are two sets of counselors here. So the Healing Place in Jackson. He does see, I need to make a call to them because I just found out he was seeing an intern there. So I'm a little more concerned that, he's not processed with maybe a full therapist and what their idea is. He's also explained to me that he doesn't think he needs counseling. I'm a little concerned that if we just threw him back into that he may need somebody to process with. I did speak to his mother regarding that matter last Wednesday and informed her that, I strongly encourage her to speak to those people and continue his counseling, especially through any reunification process.
So it sounds like if there were any modifications to the bond conditions, your recommendation would be, the contact with the younger children, I'm guessing supervised by the mother.
I think that maybe a therapeutic would be beneficial as well, and maybe even accompanied by maybe a trauma assessment where they would be able to deal with some of the bonding issues between the parent and the child and how that goes.
And would that be, and then, I'm sorry, so is that the recommendation for all of the children?
Yes, all three. Specifically the victim.
And the children are with their mothers or in the care and custody of, and it looks like the oldest one is still staying with the maternal grandfather?
Yes, he is staying with the maternal grandfather. He has his own room there. Often when I visit, they're doing a lot of projects together. The grandfather lives in the school district with which he is currently attending.
Is there anything else you'd like to update the court on?
They did actually have some visits that were facilitated by Mr. Sherwood's stepmother and father. Though that went really, really well. It was an overnight where all three children were together. There was some apprehension from the youngers wanting to be around their brother. But I think that bond is very strong. So it was kind of, once we saw him, things were good. So I would like to, continue that. I know that I spoke to Ms. Sherwood about contacting and maybe the older brother coming to the home. We had discussed that he could reach out to her and speaking with the older son, he could contact her and maybe they could set something up. So has that happened? I'm not sure that happened. That was the 26th, though, in the last week and a half, basically.
How old is the older child?
14, I believe.
14, okay. And do you have any concerns about him being the one to reach out versus just like the adults maybe trying to coordinate?
It can be either way. And as a matter of fact, he turns 14 tomorrow. So yes.
He's not that age.
Yes. So, and I know that the maternal grandfather has been open with communication with Mr. Sherwood's parents. So there is some dialogue going on and working together.
So the kiddos are able to see other family members?
Correct, yes.
Okay, wonderful. Thank you for that update. I have no further questions, Your Honor. Move to admit the court report.
No objection.
No objection.
Thank you, they are received. I have the 2 certificates. I don't have the third.
I will be presenting that, Your Honor.
Okay, all right. Questions for this witness?
Hey.
Mr. McFarland?
My understanding of the third document that you're aware of is another Michigan State University extension, a completion of a relax program. Is that correct?
I've viewed it briefly, but if that is the one that he would email to me, yes, that is.
If I may approach the witness, Your Honor, or have the bailiff present.
Okay.
Asking you to take a look at this document and see if that's the same one that was emailed to you, which I've shown to all the counsel, Your Honor.
I believe that is the one,
Thank you.
yes.
Without objection, Your Honor, I've showed it to fellow counsel if that could be admitted as a document,
No objection.
evidence.
No objection.
Sure. Deputy Ames or Mr. McFarland, whoever would like to deliver that certificate to me. I can't quite reach.
And you shouldn't have to.
Thank you. All
Sir-
right.
Oh, thank you. Sir, is it my understanding that mother is of the position that she's okay with supervised visits when or if the no contact terms of my client's bond are lifted? Is that-
Which mother, Mr. McConnell?
Well, how about the mother of all the children,
Okay.
The mothers plural.
Mothers plural, got it. I believe, yes, when it comes to Miss Sherwood, absolutely. We've discussed that at length, multiple times, that it would be in the best interest, just because the children are kind of displaying some behaviors. As for the older son, yes, I think we're all in agreement. We just, in terms of speaking to the mother, that yes, she's in agreement. She does know that her son does want to see his father, structured to start and then proceed from there.
So with the agency, do you have a position if the court would permit parenting time supervised under the structure you had discussed in a therapeutics setting, if or when my client's bond conditions are modified? Would you have any objection to language like that?
I would not. The goal has always been reunification, Mr. McFarland, so that we have to take those steps once those, and the bond conditions is the barrier at this point.
And lastly, I understood there's a psychological evaluation scheduled, correct?
Correct, at Mr. Sherwood's request.
You understand my client might not be able to answer some questions on the ground it might incriminate him in a ongoing criminal case. Do you understand that?
I do understand that. And again, I do stress that that was his request, not necessarily from the department.
Right,
Okay.
just so you realize it's not a lack of cooperation perhaps, but because of the criminality of the other case.
Yes, sir, I understand.
Thank you. Nothing further.
Ms. Heiss.
So the mother of the oldest child
Yes, ma'am.
has gone, the family met in family court in Jackson recently, in custody court, correct?
Correct. She has.
And that mother left custody with dad.
So it's my understanding, and I do not have the documents in hand. I spoke to her last week and I have not acquired those yet. That the referee and or judge had stated, because we have this case going on and an order placing the children or her son in her care, that they were going to defer to that order at this time. That's how I understood it.
This child is not in her care, would you agree?
She spends time with him, but yes, he does reside at his grandfather's home.
Okay, and then we need an updated DHS 69 with everybody's addresses and phone numbers. Or I didn't get one if he's filed one.
I have not filed one. I do know that in our correspondence, you did not have a correct phone number for the oldest son's mother. Other than that, on the court report, if you look on page 2, it does have the mother's the father and their correct information, although I do need to correct the oldest child's mom's phone number.
So the oldest child on page 2, is this his mother's address or his grandfather's address?
That is his mother's address. If you'd like me to add the other or provide that, I can.
Well, he doesn't live with his mother, right?
He does not stay with his mother full-time, no.
So if you place this child with the grandfather, what would be the negative involved in placing him there?
When I acquired this case, I think that we were just keeping status quo at the moment. She is very much involved. She does see him on a regular basis. So we kind of treated it as if, you know, hey, I'm going to stay with grandpa. And if we need to make something more formal, I have no objections to working through that.
So we don't have any counseling reports for the kids, correct?
I do not. Well, so the 2 younger, a couple months ago, I know Mr. Sherwood was redoing his insurance. Ms. Sherwood had, in August when we had discussed, I think she was talking about moving her job. So we were looking for a counselor possibly in Adrian. And because that would be potentially where she's moving, because her previous job was in Jackson, I think they have now settled on Brooklyn. So those 2 young children have not gone through counseling. I do not have a counseling report for the older son. He's been involved for about a month.
And no report for the youngers?
They haven't seen a counselor as of yet.
How about a counseling report for dad? Anything?
So we had discussed him attending counseling. I know that he, again, had some insurance issues when we first started this. He, because of his work, has not been able to find a counselor or secure counseling for himself.
Okay, and Colton, the oldest child in this case, wants to return to living with his father. Is that correct?
He has voiced that, yes.
And the 2 youngers want contact with their father?
Yes.
Nothing further, thank you.
Any redirect? No. Thank you for your testimony. You may return to your seat. Mr. McFarland, I'm assuming you have no other questions?
I have no other questions.
Okay.
Just
Thank you, Your Honor.
Thanks. All right, Ms. Thomas, anyone else you'd like us to hear from?
No, Your Honor.
Mr. McFarland?
I've discussed that with my client, Your Honor, and she's choosing not to with the criminal case.
Ms. Heiss?
I have no witnesses today, thank you.
Comments in closing, beginning with Ms. Thomas?
Your Honor, I would like to commend Mr. Sherwood for doing what he can. I know that it's kind of a tough situation with the 2 courts trying to balance the things not happening in the 2 courts. I think that the attorneys can work with Mr. Mawad to try to draft something so that the bond conditions in circuit court can be modified. It seems that that would be in the best interest of the children, given their expressed desires, and then also the observations that Ms. Heiss has put forth. It seems that that's kind of in everyone's goal at this time. I think that the family, as Mr. Varian stated, the family, especially the children, may benefit from therapeutic parenting time or trauma assessment to ensure that they're receiving any services necessary to deal with this disruption in their normal home environment. And then when they are finally reunified with one another, that they can move forward in a healthy manner and avoid any other disruptions and can be together without any concerns of physical abuse or the like. So with that, Your Honor, we are asking for another 90-day review. I think at this point, we may even be able to ask for a 6-month review if the court deems that necessary. But I think that the 90-day review would be beneficial with the understanding that hopefully by the holiday season, we might have some modifications to those bond conditions. And if this court's order needs us to provide that information to you to modify any of our orders, we can do so. But I think 3 months is probably fine. Thank you.
Mr. McFarland?
I agree with the 90-day review to keep this moving, Your Honor. The dynamics, we have something lifted on the criminal case. I would ask that in the event that that does occur, that the agency would be able to explore visits as expressed by both the worker for the agency, caseworker, and the GAL, Your Honor, as in the best interest of the children. Perhaps, as a guardian item suggested, that it may assist the criminal court, and we could perhaps have language that client may have parenting time at discretion of the agency if and when terms of bond are modified for contact with minors. So, just a suggestion. Thank you.
Thank you, Your Honor. We've been here almost 4.5 months, and we're relying on the children and the parents of the children to tell us what's best for the kids. We don't really have professionals telling us who's ready, but I would ask you to consider that placement with the oldest child is placed with mom, living with grandfather, and that works because we're hoping this would be short term. Grandfather does not really need the finances and that kind of stuff, but I do think it's important to continue to remind the court that that's the person who's taking care of his daily needs. That fella had a motorcycle accident, but he is perfectly capable and willing and doesn't need the financing of placement there, but that is what's going on. The child is in that person's school district. He's playing football. He's hurt right now, so he's not playing, but you know, everybody thinks this is really temporary, and I don't doubt them. There's no professional here to tell us that they need longer term, and it's a real holding pattern for these kids. And I do think that in the absence of any other information at this point, that we should reunite for visits, at least for visits. Thank you.
All right, thank you. The court finds all interested parties are given notice for purposes of today's hearing on the review. I will agree to authorize that therapeutic supervised parenting time in the event that the bond conditions are changed in Jackson. I will ask Mr. Farian to take us up on his offer, or I'll take him up on his offer to refer at least the oldest child, if not all three, frankly, to a trauma assessment that would include a bonding assessment. So you'll probably also need special permission from the court in charge of the bond condition, or in charge of the bond conditions for dad, to modify to allow for that bonding assessment. The supervised therapeutic parenting time resources may be tight, as we learned in our last hearing. So if there is a liaison in Jackson County or some other service providers that we can hook into, that may be of benefit in looking at this particular service for the family. In the meantime, the children will remain with their non-respondent parents under their supervision and care, as well as the monitoring and supervision of the department. We'll continue to count on to make referrals for the children and for the parents as necessary. I'd like to see some referrals from Mr. Sherwood as well, and to start some specific education, maybe with a counselor around discipline. I don't think he needs to necessarily get into what would be a compromise on his Fifth Amendment rights, to simply learn some good de-escalation skills, for example, and some parenting alternatives to using simply physical discipline, which obviously needs to happen in this case. And it looks like he's willing to do it. So let's get him some services on those points in a way that obviously honors his Fifth Amendment rights and the pending allegations against him, but gives him an opportunity to start growing and moving forward, so that when the family does reunify, that it's a good, healthy, safe environment, like Ms. Heiss said. So our caseworkers, everybody's in compliance with their obligations to this family. It sounds like a difficult situation with everything still pending, so I wish you the best of luck on that. We'll do what we can to support you and to give you the services you need to get through this time. Mr. McFarland has a question?
No, I just have clarification. The court's going to reference a circuit court case that is here in Lenawee County, not Jackson.
Oh, thank you. All right. So I thought I read Jackson, but that's okay. Wherever it is, you can use my order to try to ask for that, but I would definitely recommend that you get that trauma assessment in line right away, because that bonding assessment could be very useful to you in navigating that request to the circuit court. All right, we'll have our next review 90 days out as requested by everyone on January 6th at 1:30, unless anyone has a conflict that day. Children will remain placed, that's their least restrictive circumstances, they're with parents. And I think that's it for tonight. We'll see you in January, good luck. January 6th. Yes.
Okay, Mr. Mawad, I do have Mr. Sherwood here.
Thank you, Judge.
You need a breakout session with Mr. Sherwood?
No, I think we're ready to go, Ms. McClure, I think, and I talked probably just a little bit more time, Judge.
I'm here to address bond conditions with Mr. Muad.
Okay.
Half of Mr. Sherwood.
Oh, hi, Lee.
Hello. I'm his
All right,
attorney in the abuse and neglect case for lawyer guardian ad litem.
Yeah, very familiar. Thank you for coming on. Thank you.
All right, Mr. Sherwood, are you there?
Yes, sir.
People versus Charles Thomas Sherwood. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Elias Muad appearing on behalf of Mr. Sherwood.
I'm Lee Jamison Heiss. I am on behalf of Mr. Sherwood today too.
All right, so where do we stand with Mr. Sherwood's case today?
Ms. McClure did receive, go ahead, Phoebe. Go ahead, Phoebe. I'm sorry. So sorry. Go
As
ahead.
it relates to the underlying pretrial judge or the underlying criminal charge, I did receive some information from Mr. Muad that I've, excuse me, reviewed that may change what the resolution or the offer is in the case as it stands. I just need a little bit more time to flush that out with Mr. Muad and try and figure out what we can do on this. So this time we're asking for a short pretrial adjournment, maybe 3 weeks or 4 weeks at the most. And then I've also been from probate court given a heads up as to what they're recommending as far as I guess parenting time, we'll call it, with the parents, and assuming Ms. Heiss can explain that. I don't believe I have an objection to it. I would like that his bond conditions mirror what the probate court orders are, but I want to make sure it's what I was informed of.
Okay. So Mr. Muad, do you have any objection to an adjournment, say, to November 6th?
No, Judge, that's fine, and that's what I contemplated along with my client. He understands.
No. Okay. No. So we will adjourn that to November 6th at 8:15. And
just not to interrupt, but Mr. Sherwood is shaking his head no. I don't know, is that date not good or?
Mr. Sherwood, what's the matter?
Just being postponed. That's my problem here.
Mr. Sherwood,
Lee,
hang on. Don't say anything. Lee and I will talk to you. I think we have a plan here. Is it okay on the 6th? Are you available on the 6th?
Yeah.
Okay,
Yep.
That's it. Thank you. Thank you.
Okay.
All right.
all right, so let's go ahead and address the bond issue then.
Your Honor, Lee Jamison Heiss. I am the lawyer guardian ad litem for the minor children in this case, one of whom is the alleged victim. In the abuse and neglect case, that's filed 24A. As recently as October 7th, Mr. Sherwood was found to be making progress. He has accepted responsibility for jurisdiction. The children are placed with their mothers, and there has been no contact with the children to this point. On October 7th, Judge Sala did order supervised visits if this bond condition were to be modified, so that if you would allow your case to mirror our case, he would have to participate in a trauma assessment with the children and some therapy, but also supervised visits would be allowed. At this time, I have met with the children face to face, and I do believe that is in their best interest.
No objection, obviously, Judge, on my part.
Okay, Ms. McClure.
Just to clarify, is that with Colton as well, or just the other children?
It's with all three.
How would that look with Colton?
So the judge has ordered, let's see, the exact language in the order. He's to cooperate with a trauma assessment, so he will see those children at the trauma assessment, and the visits with Colton are therapeutic supervised. So they will be supervised by an actual therapist, not a family member or something like that at this time.
And where is Colton living at this time?
He is placed with his mother, living with it, but technically living with his maternal grandfather in Napoleon, Michigan.
Okay. And when this was brought up in district court, Mr. Sherwood was represented to me that he had no interest in seeing Colton again. Is that changed?
You know, I don't know that side of it. I can only say that Colton's needs and interests, when taken as a whole, his school history, his home history, his personal feelings, he would like to have this therapeutic supervised visits with his father. I don't know that his father will participate. I don't have his confidence to have inquired.
Okay. Judge, at this time, I have no objection to the bond conditions in this case being modified to mirror the probate court order, the current probate court orders and any future orders that may come down, however that looks.
Okay. All right, so the court will then modify the bond conditions. I guess, is it sufficient that I just say that they must comply with the probate court's orders in the abuse and neglect case?
Yeah, and maybe
rather than try to explicitly state them in this record.
Yes.
Yeah, and if you want to clarify in your order that pertains to contact with Mr. Sherwood and any minor children, I think that would be sufficient.
Okay, so I'm sorry, is that agreeable, Ms. Heiss and Mr. Mawad?
Yes.
Yes, Judge.
Okay. All right, so I will modify the bond conditions in that way. Let's see, Ms. McClure, would you do a stipulation in order for the adjournment?
Yes, I can do that. That was November 6th.
Correct.
Correct.
Okay.
All right, are there any other issues we need to address with the case today?
Thank you, Ms. Jamison. Thank you, Ms. McClure. And to Judge Charles, or Mr. Sherwood, I will call you later on, okay?
And
All right.
nothing on behalf of the people. Thank you.
All right.
I do want to ask, does that change the tether coming off, or does that stay on? How does that work?
Well, I can ask Ms. McClure how she feels about the tether. Do you still need it on, Ms. McClure, or what do you think?
If there have been no violations, I would leave it in the discretion of the court.
And I'm not aware of any violations. I think Mr. Coast may still be on there, but I'm not aware of any.
Ms. Heiss, do you have any input on that issue?
He is doing his case service plan, and so on our account, he is in compliance with his terms of the abuse and neglect case, if that helps.
Okay, Mr. Coast, any input on the tether issue? I don't know if you said anything, Mr. Coast, but your device was muted. Did you have any input on the tether issue?
Judge, he has been on GPS tether. He has done a good job with that. I received no violations to date.
All right. So at this time, then I'll also eliminate the requirement of the GPS tether.
Charles, I'm going to go ahead and get a hold of JSG. You can return your device at this time then.
Okay, thank you.
All right. If there's nothing else, then everyone can log out.
Okay. Mr. Sherwood, you can go and wherever you put it on, you can go back and they'll take it off. Okay.
Yep. Thank you, sir.
All right. All right, Ms. Heiss, thank you. Oh, she's off. All right. Bye. Bye.